Hi, everyone. I'm Margo Lindauer. I'm a current law professor and former director of the Domestic Violence Institute at Northeastern University School of Law. Today, I'm going to be talking about the Supreme Court case that just came down, barring domestic violence abusers from owning guns. And while this has been framed in certain circles as a domestic violence case, it's also a very large Second Amendment case, which is the right to bear arms. I am not a constitutional expert by any means. My legal background has been mostly focused on domestic violence and sexual assault, but the intersection between the Second Amendment and domestic violence is interesting and quite obviously very lethal. So the right to carry arms or guns, in this case in this country, is part of the Constitution. When the Constitution was written in the 1700s, it is the Second Amendment. And as laws have developed over time, we have created as a society legal mechanisms by which individual people who've been victimized by other people who are in an intimate relationship with those people, meaning dating, sexual, marriage, familial, and suffer abuse, can seek a civil restraining order or a civil protection order. Those are civil, they are not criminal. They're also criminal orders, but in this case, we're talking about civil protection orders. I'm going to be using the term victim to identify the person seeking protection, though sometimes that term isn't always desired. That's the term that the courts often use. Typically, when someone obtains a civil protection order or a civil restraining order in this country, immediately the abuser or the defendant in the matter has to hand over their guns, because there is the assumption that if a court has found someone to be a high likelihood of harm to someone else and they own guns, that then they are an even higher risk of harm to others or themselves. In the DV or domestic violence community, there's been a lot of fear associated with the outcome of this case, because while guns don't exclusively mean lethality, guns are a huge lethality factor in domestic violence cases. So if an abuser has access or owns a gun, the likelihood of fatal harm to their victim is much higher, just because it is much easier to harm someone with a gun than with their bare hands or with a knife. Right, there is that space of separation. It is not as personal of an act to use a gun as it is to, for example, strangle someone with your own hands or use your own body to harm someone. So access to a gun, particularly if someone has used a gun in the past, is a very, very significant lethality factor in these cases. And there was a lot of concern that, given the makeup of the court and how many folks feel so strongly in the fundamental rights of the Second Amendment, in particular, the right to bear arms, the right to own guns, that the verdict would be very different. But advocates and attorneys and victims and survivors alike breathed a huge sigh of relief this week when the verdict came down 8-1 in favor of affirming what the law already says, that perpetrators of domestic violence who own guns must turn over their weapons. Thomas dissented. Thomas often goes back to the plain language of the Constitution. And what we all know is that the Constitution was written in a time in this country that is very different from the current times. And so seeing how the different justices use this document, either as a living document or a modifiable document, or trying to modernize the document, is something that we really should keep an eye on, with so many really important cases going up to the Supreme Court in the coming years. I think we can agree to disagree, but my position is that this document was written in a time where folks couldn't have ever imagined where the country would be, both in terms of how we live, who lives here, what technology has done, how we work, how we have families. And so kind of using this document as the bones of how we analyze is something that obviously the Supreme Court has to do, but how do we make it more modern and take into consideration how the founders of this country and the people who wrote the Constitution weren't thinking about a lot of the elements of life that we have to confront today. Fascinating and kind of hopeful that the majority of the justices acknowledge that domestic violence, as we understand it now, wasn't against the law when the Constitution was created. Domestic violence was a familial issue or a privacy issue. It's something that happened at home. God knows how many people, women and children in particular, died at the hands of their abusers. And that how the Second Amendment was envisioned, it wasn't written at a time where they were taking into consideration crimes of domestic violence. So this is huge. And this is, I mean, it's huge and it's not huge. Nothing changes, right? So we still have a really flawed system where lots of people are not kept safer by current policy and laws. But we haven't gone backwards in this regard. I'm Margo Lindauer, and that's the law.